You're watching the Law and Crime Network. Aaron Keller with you for the afternoon hours here, and the defense has rested in the Todd Kendhammer case out of La Crosse, Wisconsin. We just heard the prosecution say that it plans to call two very brief rebuttal witnesses, waiting to see exactly who those witnesses will be and what they'll have to say. In the meantime, Andrew Maloney is back with us, former federal prosecutor, currently in private practice. Andrew, good to see you again.
Nice to be here, Aaron. Thank you.
So, we were just listening to the testimony from the daughter, and it seemed to be, in this case, mainly for sympathy. I didn't really get anything probative out of it. Did you?
No, there was nothing material that explained anything about this case. So you're right. She was just there to garner sympathy. She obviously mourns the loss of her mother. She, of course, loves her father and doesn't want to believe that he committed a murder. So she's on the stand to try to garner sympathy with the jury.
We wound up with an interesting situation in this case, I think, because after the state's case in chief, I was sort of teetering back and forth between guilt and innocence. If I were to be on the jury, I'm not quite sure where I would have voted, because I have to take the situation and then say, okay, the state has a very high burden of proof here, and I'm not sure that they cleared the hurdle. Well, then the defense's experts started to fall apart on the stand, and the defendant himself just got pummeled on cross-examination yesterday. And at the end of that, I was willing to just sit here and say, okay, I think I would have to vote guilty at this point. So that led to a rather feisty debate back and forth between one of my guests yesterday and myself about whether or not the defense did more damage to itself than the state did to the defense, and how the situation was sort of backwards from what it's supposed to be.
They rolled the dice. It's a big risk whenever you put the defendant on the stand. Most defense lawyers will not do that. There's a variety of reasons, but the main one is if your client, the defendant in this case, has weaved a web of lies or has a lot of inconsistent statements, they're going to be exploited on cross-examination by a skilled prosecutor, and that's exactly what happened yesterday.
I thought that the prosecutor was perhaps the best cross-examiner that I've ever seen. And it's interesting to see that. This is a pretty rural jurisdiction, but that prosecutor was right on top of him. Almost went so far as badgering, but didn't quite cross the line. He towed right up to it, but didn't cross it. And I thought that was a phenomenally good set of cross-examination. And the defendant was basically just saying, well, I can't answer that, and what I told you originally wasn't true. But then he said it wasn't true, but it wasn't a lie either. And myself and a bunch of people in our chat rooms were sitting there asking what that is. What is not true but not a lie? Is he trying to say that he got the story wrong, but it wasn't deliberate, that it was mistaken?
I think in his mind, there's a difference between making a mistake on a prior inconsistent testimony or remembering it different later on versus intentionally lying about something. It didn't come across that way. I think in his mind, he was trying to somehow explain it away. It didn't work. When you tell a lie, you have to be able to be consistent, and he was inconsistent. And when you lie, sometimes you can't explain lots of parts of your story that you've tried to weave.
One of the things that struck me in the interrogation, and of course that's what we're trying to compare the testimony to, was the interrogation in the police interview room. One thing that bothered me is that he kept saying over and over again in the interrogation, I don't know the answer to that. I'm not sure how it happened. It was an emergency. I didn't notice that detail. I'm not sure. I realize that it sounds far-fetched, but I don't know. And the police just kept pushing him and pushing him and pushing him, and he started speculating. He said, well, I don't know, but maybe it happened this way. I'm just trying to give you a theory to maybe help you out. And they kept pushing, and he kept speculating and speculating and speculating, and now they're trying to hold that speculation against him. So clearly what should have happened is he should have invoked counsel, and he almost did, but he didn't. That would have shut the whole thing down. At least it was supposed to. It should have shut the whole thing down. But he didn't do that, and now he's stuck trying to explain away some of the speculation in the original interrogation. And I would hate to think that the speculation is what's going to put the guy behind bars, not an actual affirmative answer to a question.
I'm a little bit more cynical than the way you've described it. The speculation that you've described, I think, was his attempt to try to come up with an explanation. And when the first one didn't satisfy the police because it didn't make sense. He came up with another one to see if that would satisfy them, and that one didn't work either. So I think, you describe it as speculation. I think that was his attempt to try to come up with some explanations, and once he did and it was full of holes, he moved on to another one. And I think he did that all the way through trial in his testimony. He should never have taken the witness stand here. If this was a closed case before he got on the stand, he made a huge mistake, because I don't think it's very close anymore now that he's testified.
Exactly. Not only did he damage himself, but his experts were really back and forth. I mean, they were vacillating. Some of them had the facts incorrect. The core of their testimony is that, okay, well, in their opinion, this could have happened the way that he claimed it did, but then they admitted, well, it also could have happened one of 20 million other ways, which could have involved him attacking his wife. So at this point, you've got the defense experts agreeing with the state's theory of the case, but I will say, to the defendant's credit, some of the state experts were backpedaling on cross-examination as well, saying, well, either I don't know a lot about that, or maybe it happened that way, and they were backpedaling in their own right. So you've got state experts agreeing in part with the defense.
Well, you often have a battle of the experts, and the jury has to weigh that. They have to weigh the expert testimony. Sometimes they cancel each other out, and you're left with the defendant's testimony in this case and some of the other testimony that you heard and some of the other evidence. To me, the most important evidence in the case may be the forensic evidence. He claims that she was hit by a pole that penetrated the windshield and hit her in the head, and yet her body showed signs of strangulation and bruising about her body, gashes on her head in different areas. It doesn't seem to be consistent with a pole coming through the windshield, which you would think would essentially hit her in the head and be confined to one area of her body, in her head, and yet she's got these other injuries. So that, to me, was a red herring. I think that's probably what led the police to immediately start to suspect him as a potential murder suspect.
Yeah, I mean, one thing that we've been trying to figure out is whether or not she was drinking from this cup that was broken in the car, because she has an injury pattern around her mouth and her lips, would suggest that maybe there was some sort of an impact there, as if she had the cup up against her upper lip and it pushed back in.
Or a fist.
Yeah, okay, so and then we keep going with what ifs. I mean, is that it? There was a piece of plastic from the cup that was in the windshield. Why is that? Is it because she was drinking from the cup when the pipe came in? Did she hit the windshield somehow? Did he slam on the brakes and she hit the windshield? Well, he claimed that he didn't know if he slammed on the brakes or not. There's all these what ifs. Or did he use the cup to try to break the windshield, because the state's accusation is that the windshield was broken by the defendant? So there's evidence that could argue that point both ways.
Yeah, I mean, look, one of the sort of the best things the defense has going for it is potentially the lack of motive, which is why you heard from the daughter, and I think the son testified that they had a good relationship. There were no financial problems. There was no real motive for him to kill her. That's essentially what the defense has tried to lay out in this case. And we all know that when a spouse is killed, the other spouse is often the primary suspect until you see some other evidence. So he had to initially be considered a suspect if they thought this was a murder. We don't know what happened in terms of what caused, if he did in fact murder her. We don't know what caused the fight. Maybe he snapped. Maybe there was something that we just haven't learned about. Somebody was having an affair. Sometimes, there's a whole bunch of reasons why marriages essentially don't work out, or one spouse snaps on the other. But of course, he's now stated that wasn't the case. It was this other, in my opinion, far-fetched explanation of how she was killed. Just hearing his explanation, it would be 1 in 1,000, maybe more than 1,000, to have a pipe fall off a truck, hit the ground in such a way, and not turn that pipe in any direction other than a forward-facing spear-like direction, hit through the windshield, hit her in her seat. There's no signs that he, skidded on the highway. In fact, he drove off the highway to do whatever it is.
Side road, and
I
then
mean, there are so many things he's tried to explain that do not add up. And I think his testimony is going to do himself in this case, coupled with the forensic evidence.
Yeah, I mean, one thing I think that the prosecutor successfully exploited yesterday is this concept that he sees this object flying towards him in his version of the story. And first he thinks in a split second that it's a bird. Okay, and then he says he, goes to punch it out of the way and doesn't realize it's a pipe until it crashes through the windshield. Well, if you didn't know it was a pipe, then how would you know it came from the truck that you described? The prosecution didn't go quite very far into that, but they did say, well, if you thought it was a bird, why'd you try to punch it out of the way with, first it's both hands, and then it's just your left hand, even though you're right-handed, so why would you keep your right hand on
the right hand's closer to her
wheel and then try to punch with the left hand while you're driving?
Makes no sense.
And why would you try to punch a bird out of the way? That's what they tried to pin him on, and he's just like, well, I don't know. I mean, because usually you hit a bird with your windshield, you feel sorry for the bird, but the bird bounces off.
But Aaron, this is another example of when you try to make up a story and then somebody literally starts to ask simple common sense questions that you didn't think about when you were telling your version of the events. You cannot explain it because it's a lie. It didn't happen that way. So that's where he got himself in trouble. He told too many different versions with too many inconsistent explanations, many of which didn't make any sense. And so his testimony in this case is the turning point. And I think the jurors, and if I were a juror, having listened to him, I would now feel fairly confident that he murdered his wife.
So let's talk about his decision to testify. Obviously, it's his decision and his decision alone, and every judge goes through that in every single trial that we watch to make sure that it's on the record, that it's the defendant's own decision. But one has to wonder, and of course we'll never know what the conversation was back and forth between counsel and defendant in a situation like this.
Yeah, most defense lawyers would tell you don't put your client on the stand. Hold the state to its burden of proof, which they should have done in this case. Now, it may be that the lawyer did tell his client don't take the stand, and he said, I'm going to do it anyway. Or it may be the lawyer thought, collectively with his client that, yeah, I think it's worth the gamble. You're a nice guy. People will like you. You're just an ordinary guy like them. Your son's going to testify. This whole family thing. Let's give it a shot. It was a huge mistake. It's an easy decision when your client has a prior past criminal record, for example.
Yeah, because then they testify, then it comes in, and then it's game over.
Right, and this defense lawyer may have thought, okay, he's got no real skeletons in the closet for me to worry about on the witness stand in terms of prior criminal acts or prior bad acts or anything. There's no skeletons, so let me take a gamble here. It was a mistake because what he didn't consider is the prior inconsistent statements post-arrest and what would happen on cross-examination with a skilled prosecutor. He had a good prosecutor on one side, and he had a lot to work with because the defendant himself handed it to him.
Well, and you also have a skilled defense attorney. I mean, this is a defense attorney in private practice. The last I knew, his office was literally right across the street looking at the state capitol building in Madison. He's trying a case 3 hours away from home, doesn't have a relationship with the judge, granted, but this is a guy at a firm that specializes in criminal defense. He was hired. You had a $14,000 expert that a lot of people think didn't accomplish anything for the defense. There's money being thrown at this. I mean, this individual, this defendant, has assets. He's not indigent. And we don't have an attorney on per diem. We don't have an attorney appointed. We don't have a public defender here. But now we're sitting here questioning some of the tactical decisions. One has to wonder what would have happened in this case had there not been testimony from either of the two experts, had the defendant not gotten on the witness stand, and the only thing we had was perhaps a couple of the family members just because they're really not going to harm anybody. And this one witness that the defense called yesterday who saw a pipe laying on the side of the road not far from where this happened. And there's a photo of it, and it looks awfully similar to the pipe that the defendant claims struck his wife. So that witness would have injected more reasonable doubt into the case, and you wouldn't have the issues with the expert or with the defendant. That might have been a stronger trial.
Yeah, if he didn't testify, I think it's a closer call. It's a closer case because the jury starts to wonder, in terms of the battle of the experts or some of these other witnesses, they wonder about motive. It seemed like they had a good relationship. There were no skeletons in the closet, no financial problems, no constant fighting, no domestic violence, no girlfriend or boyfriend from one of the spouses. So, they're probably wondering what would be the motive here. And that's, as I said earlier, a strong point for the defendant. That's why the daughter was asked about the relationship, for example. But it doesn't do much to explain some of the evidence here, a lot of the inconsistent statements, and frankly, the far-fetched way he described this accident occurring.
Yeah, exactly. It looks like we're coming back into session in court, so let's go back to La Crosse, Wisconsin. We're watching the Todd Kendhammer case, a husband accused of killing his wife.
I want to put on the record before we bring the jury in.
Judge, I would need to renew my motion for a directed verdict, considering we're about to rest. I don't want to bring the jury in, rest, and then kick them out right away to renew.
That's fine. That's something to put on the record, so that's good. Go ahead.
The argument about the directed verdict and the renewed motion thereof is, to me, intertwined with why 517 needs to be read. And I don't know if you want me to do this right now or if you want to do this piecemeal about...
Well, let me ask the state. Can you argue for 517 right now?
I believe so.
Okay, go ahead. Do them both.
So when I asked for a directed verdict some days ago after the close of the state's case, the thing I complained about was that the state has not presented a cause and manner of death. They have simply said that the story that Todd Kendhammer has provided is not consistent with what their evidence or their viewing of the evidence suggests. But they've never told us, the jury, anybody else, how they think Barbara Kendhammer was killed. At one point, there was testimony about could her head have been struck against the side of this tire and rim, cause these injuries, cause the death? Could somebody swinging a pipe cause these injuries, cause the death? Could somebody choking cause these injuries, cause the death? Could somebody strangling cause these injuries, cause the death? They haven't told us this is what we think caused the death. That, to me, provides the basis for the directed verdict motion because they've never told us. But as it relates to 517, without a reading of 517, we run the very real risk of the jury going back and one juror saying, well, gee, I think he hit her with the pipe. And another juror saying, well, I think he hit her head on the tire. Well, it doesn't matter. If you think that and I think this, we'll convict. I don't believe that's what the law is. I believe the law is that the evidence, when there's evidence of multiple ways an offense could have been committed, that it's incumbent upon the court to read to the jury that they need to unanimously agree as to how. And I don't think that we have, under these circumstances in this case, I don't think we have that. So all I'm asking for is that 517 be read so this jury is well aware of the fact that they need to be unanimous in their belief or disbelief of the manner and mechanism of death.
And tell me, where does that fit into the first element?
That he caused the death? Because it's causation. It is the first element.
But tell me how that fits into that instruction.
Because they have provided you with multiple forms of causation.
I only heard one through this trial, death by multiple blunt force trauma, if I remember that right. Isn't that not correct?
There was strangulation, there was choking, there was blunt force trauma.
I think that the doctors the state called testified that the cause of death was based on blunt force trauma. Am I mistaken on that?
Blunt force trauma can be caused, as the doctor said, by multiple mechanisms. And whether it was the tire or the pipe or some other mechanism, the state has never said. In fact, they've kept the door open to any one of those causation methods.
Okay, Mr. Grinke?
Your Honor, I think Mr. Bednarik is 100% wrong in his belief about what the state has to prove. This instruction not only should not be given, but I think the defense should be kept from arguing in closing that we have to prove something that we are not required to prove. The elements only require that there was a death, that it was an intentional, and that his acts were a substantial factor in causing that death. The cause of death, as listed by Dr. McCubbin, was blunt force injury to the head. The fact that you also might have injuries to the neck, that she may have been strangled, the fact that you also might have injuries to the arms and legs is just relevant to the fact that it was an intentional act. You don't have to describe he hit her with the right hand this time, the left hand this time, a board this time, a rock that time. That would be impossible in almost any case. The jury instruction 517 in the notes starts out by saying this instruction should be considered for use when the defendant is charged with multiple counts and evidence of more than one act is offered as proof of one or more of those counts. That's not what we have here. We have one count. The jury instruction goes on to list a number of times when this jury agreement is not required. One is when bodily harm was caused by the slap of a hand or hit with a board. Similar to this case, we do not have to have all the jurors agree that each injury was committed in one exact way that's unanimous. They do have to consider that there was a beating, that there was blunt force trauma, that he caused it, and that she died as a result. And that's all we have to prove. It would be possible in any homicide case to prove exactly which injury happened in which order to the exclusion of all of the possibilities. It would be impossible in this case to charge more than one count of homicide, and I think that's a good way of looking at this. This instruction, where I see it was given, has been given where, for example, 6 acts of sexual assault occurred, the prosecutor charges one count, and there's a defense to some of the acts but not some of the other acts. In this case, the way the jury instruction would read, that Mr. Bednarek is asking for is a defendant's charged with one count of homicide. However, evidence has been introduced of more than one act, any one of which may constitute homicide. That's clearly not the law. We would not be able to charge multiple counts of homicide. This all happened in one transaction, one victim, very short period of time. All the injuries point toward intent and causation of death, and it would be impossible to have a requirement that the state prove jury unanimity on exactly what the order of each and every injury is on her body. I ask that you deny the motion to add this jury instruction. Looking at the notes, I think it makes it clear that all the case law will be on the side of the state in this situation, and also keep the defense from arguing that somehow we have to prove one consistent theory to explain every injury.
Anything else on the motion to dismiss at this point?
I'd repeat what I said already and also repeat the argument I made after the rest of the state's case. I think we've proven the defendant lied about not just what happened, but tried to cover up the crime, and I think the state's evidence was clear that this was a homicide and not an accident.
Mr. Bednarek, anything else from you?
No, other than I think 150 stricken testimony would likely be deleted from this.
Well, maybe I'll have to strike something from Mr. Grinke's rebuttal. I haven't taken it out yet, but
Fair.
I sure will if it needs to come up. All right. Well, I look carefully at your argument. I think it's 4 pages that were submitted. Technically 5, but 4 pages of content. The cases cited, I think, are all distinguishable. Specifically, Lomagro, Lomagro, does talk about sexual assault, like Mr. Grinke brought up, and I think in that particular case there were 3 acts, could be 3 charges. They charged 1, and I can see where unanimity would be an issue with 1 count with 3 different acts that could rise to that. Here we have the 1 death. That's the sole charge, first-degree intentional homicide. It only has 2 elements. First one being the causation. Was the defendant's act a substantial factor to produce the death? And the second one being the intent. And with the intent, the court needs to look at the, not the court, but the trier of fact needs to look at the inferences and subsequent acts and words and statements and all the facts and circumstances bearing upon intent. And that's what this trial was. There was no dispute that Ms. Kendhammer died as a result of some injuries. The state has their theory of the case being that it was because of Mr. Kendhammer. The defense has their theory of the case that it was a result of an accident, and given everything that's been presented here, gives the jury the basis to have to make a decision as to which side is the side they can accept as their verdict. I considered the defense motion to dismiss at the close of the state's case. Now I need to consider all the evidence, and based on what I've seen now, I think that there still more than sufficient evidence for the jury to, a reasonable jury to be able to come up with a verdict of guilty at a level beyond a reasonable doubt. And they themselves could, if they feel it's appropriate, give the benefit of the doubt to Mr. Kendhammer based on the nature of the evidence, how they view that evidence, how they view all those surrounding facts and circumstances. I think 517 would be highly confusing to the jury. I tried to author it, which is on I think the last page of the instructions I gave you, and it doesn't seem to fit with a one-count case. I agree with the state that the cause of death was identified as blunt force trauma, as I indicated, to the head. There may be other injuries to her person. Those could be consistent with an aggravated battery causing her death with that blow to the head, or it could be consistent with the accident as the defense contends, but there's still sufficient facts here that a reasonable jury could find, and I don't think that there's a specific act on that they need to hang their hat. They'll find that Mr. Kendhammer had the intent to do acts that would cause her death, or they won't. And if they don't find either element, then he'd be acquitted, obviously. So I will not give 517, and I will deny your motion for dismissal at the close of your case. So anything else at this point?
No, Your Honor. No.
Okay. I guess once the state has presented their rebuttal testimony, we'll take another break at that point and see where we're at that point, and if nothing else, I'll give you another copy of the instructions to look at.
And I'll rest on the record when the jury returns.
We will. Okay? Bring him in. All right, you may all be seated. At this time, does the defense have any further evidence they wish to offer?
Your Honor, the defense rests.
Very well, the defense rests at this point. Mr. Grinke, does the state have any rebuttal they wish to present?
Yes, Your Honor. The state will call Jared Logan.
Under penalty of perjury, do solemnly, sincerely, and truly declare and affirm that the testimony about to give in this matter shall be the truth, the whole truth, and nothing but the truth.
I do.
Come over here.
Could you state your name?
Jared Logging.
And could you spell your last name?
L-O-G-I-N-G.
Mr. Logging, where do you live?
N5603, County Road M, West Salem.
On County M, are you aware of where Bergham Cooley Road is?
Yes.
Would your residence be north or south of Bergham Cooley Road?
South.
And for people who might not be good with directions, that would be closer to West Salem?
Closer to West Salem.
Are you familiar with the horse ranch on County M called the Wild Winds Ranch?
Yes.
Where do you live in relation to that?
Basically just southwest of it.
Now, do you know somebody named Todd Kendhammer?
Yes.
How do you know him?
I've known him for years through dealings with my brother, his younger brother.
Now, direct your attention to a time in last fall, September 2016. Was there a day that you saw some first responders or ambulances driving by your house?
Yes.
Do you remember if that was September 16th of last year?
I'm pretty sure it was. I was on my way to a chiropractor appointment that day.
What time was your chiropractor appointment?
8:30.
Did you see any first responders or ambulances as you drove away?
As I was entering towards West Salem, I met the first responders heading out towards my house.
What did you drive to your chiropractor appointment?
I drove my car.
What kind of car is that?
It's a little Ford Contour.
Do you also own a truck?
Yes.
What kind of truck?
F-250 Super Duty.
What color is it?
Blue.
Where do you usually park that truck?
In the front yard.
And how close is that to the roadway?
50 yards at the most.
Where you park your truck, are you able to see that truck from the roadway as you drive?
Absolutely.
Had you talked to Mr. Kendhammer about fixing a windshield on that truck in
No.
2016? Do you have two brothers that work at Crown Cork and Seal with Mr. Kendhammer?
Yes.
Are you close to them?
Not really.
Did you talk to them at all about needing a windshield for that truck?
No.
Had you had that windshield in that truck replaced or fixed?
I've had it fixed, yes.
When was that?
That was in 2014 in December. I had, my insurance company took care of it. I had full coverage on the truck. There was a rock chip in it. They fixed it. They had one small rock chip below the wiper that they didn't do, and it's still there.
Do you know a person named Chad Tollefson?
Yes.
Are you close to him?
No.
Did you talk to him in 2016 about needing a windshield for your truck?
No.
In September of 2016, well, at any time in 2016, did you talk to Todd Kendhammer or anybody else about needing a windshield for your truck?
No.
That's all I have.
Mr. Hurley?
Good afternoon, Mr. Loggy. You are Jerry Logging, correct?
Jared Logging.
And do you go by Jerry?
At times, yes.
And do you have a brother Barry
Yes.
and a brother Terry?
Yes.
Is there another brother?
Yes.
What's his name?
Gary.
Okay, if I get mixed up in this, you let me know.
That's why I'm Jared.
Good. You've not spoken with Barry in a year and a half, is that correct?
Correct.
Yeah, and you've not spoken with your brother Terry in 3 to 4 years, is that correct?
Correct.
You do have a Ford F-250, is that correct?
Correct.
And you say that there was a problem with the windshield, you believe in 2014, is that correct?
Correct.
Do you remember having a phone conversation with an investigator who worked for me, a Mr. Raymond DePrima, on May 25th of 2017?
Yes, Ray DePrima showed up at my door.
And do you recall that at that time, you told him you thought the windshield problem was in May or June of 2016?
No.
And do you recall telling Mr. DePrima that it was certainly possible that your brother Barry, who works at Crown with Todd, might have known that there was a crack in the windshield around that time?
At that time, yes.
And you don't work at Crown, is that correct?
Nope.
But both Barry and Terry do work at Crown, is that correct?
Yes.
And you would have no way of knowing whether in a conversation in the lunchroom at Crown, either Barry or Terry or anybody mentioned your name in connection with a broken windshield for a Ford F-250?
Nope.
No further questions.
Anything else, Mr. Grinke?
Just one follow-up. Just to get the timing right, did you have a problem in May or June of 2016?
Absolutely not.
Were you talking to your brothers in May or June of 2016?
No.
That's all.
Mr. Hurley, anything else?
No, sir.
All right, at this time, does any jury have a question of Mr. Logan? At least one? Okay. 539. 539. Yep. Mr. Logan, the question identified as Exhibit 539 is, do you regularly leave your keys in that truck you described?
Absolutely not.
Nothing else?
Okay. All right. Thank you. You may step down. Have a good day.
Justin Hine.
Under penalty of perjury, do you solemnly, sincerely, and truly declare and affirm that the testimony you want to give in this matter shall be the truth, the whole truth, and nothing but the truth?
Yeah, Mr. Hyman, have a seat up here again, please.
Mr. Heim, you testified previously about working at Crown Cork and Seal and knowing Todd Kendhammer, correct?
Correct.
Do you also know his son, Jordan Kendhammer?
Yes.
How do you know Jordan?
He worked summer help for a summer, and we just kind of started being friends, and I helped him work on a tractor that they were overhauling and stuff like that. I did some engine work for him and so forth.
Did you have Jordan Kendhammer's name in your phone?
Yes.
In September of 2016, you remember talking to the police about this case?
Yes.
And did you tell the police about a phone call that you got from Jordan Kendhammer?
Yes.
And was that on September 22nd, Thursday?
Yeah, that sounds about right.
Do you know what time that call came into you?
It was in the morning, shortly before 9 o'clock, right around 8:50, somewhere around there.
Do you have breaks at work that are normally a normal time?
Normally, usually certain people will take breaks at a certain time. So the whole place is not on break, you know.
At that time, what was your normal, typical break time?
Usually around 8:30.
A.m.?
Yes.
Until when?
Till about 9:15, right around there somewhere.
Do you know that this call came in during your break time or not?
Yes.
It did come in during your break time?
Yes, it did, yes.
Did you answer the phone?
No, I did not, no.
Was there a voice message?
No, there was nothing, no voicemail.
Did you call back?
Yes, I did.
Do you know what time you called back?
I finished my break. There is no reception in the building because it's all steel building. So I finished my break, went outside, called back after my break was done. So it would have been right at 9:20, somewhere after 9:15, around there.
Okay. Did you leave a message?
I did. I left a message stating that I was at work that day, and I just was wondering what was up. If something needed something, if something was wrong, give me a call back.
Did you ever hear back?
No, I did not.
Before that day, in September of 2016, before that day, when was the last time you would have gotten a call from Jordan Kendhammer?
been quite some time before that.
And what do you mean by sometime?
Probably months, I would say,
Months?
since probably when we worked on the tractor.
And when was that? Do you remember?
Probably would have been in spring or fall of that prior year.
Of 2015?
I can't positively put a date on when we did the tractor work.
Would it be fair to say at least months before September?
Yes.
That's all I have, Your Honor.
No questions, Judge.
Okay, does any jury have a question for Mr. Heim at this point? I don't see any. All right, Mr. Heim, thank you. You may step down. Anything else, Mr. Grinke?
No, Your Honor, the state rests.
Okay, anything else from the defense?
No, sir.
All right, ladies and gentlemen, I should conclude the testimony at this point. So I'll have you step out for a break of an unknown length. I have to finish up the instructions, and once they're approved, I'll get them copied. I anticipate that I'll give you my instructions up to a certain point today. And then I'll have you back in the morning. You'll hear closing arguments at that point, and I'll give you the end of the instructions. And we'll see where the case goes from there. So step out, don't talk about the case yet, and we'll have you back here shortly. You may all be seated. Right, why don't you give me the verdicts? I got one for me. Record can show we're outside the presence of the jury. I will have for you in a moment here what is called draft 4 of the instructions. You can look that over, make sure there's no issues. I'll take that off, draft 4. And then have that copied for the jury if it's approved. And I'm also giving you a copy of the jury verdict I'd like you to look at.
Judge, just to save me a little bit of time, can you tell me what the difference between draft 3 and draft 4 is? Is it just...
Well, I took 150 out. That may be the only issue, but again, if you find any other issues that you may have overlooked, let me know.
You're watching the Law and Crime Network. The state has rested its case after rebuttal, so testimony is complete, as you heard in the Todd Kendhammer case. We're waiting for the judge to review some jury instructions. He might. Sorry about that, folks. We had a bit of a hiccup there, but we're back. We're discussing the Todd Kendhammer case. Andrew Maloney, former federal prosecutor, currently in private practice, is here along with me. So we had a couple of rebuttal witnesses called by the state. One is the guy who had the truck that the defendant said in his second or third version of the story, depending on whose versions you believe. He says he never kept the keys in the truck. That was a question from the jury. That deflates so much of the defendant's story, because his version of the story is that he was going to go get the truck, presumably take it to repair it, and that the keys were in it. That's the defendant's version of the story, and his wife apparently would somehow continue on to work. That's the way I'm taking it, or at least that's an inference you can take from it. But the defendant had said the keys would be in this truck that he was looking for. That witness said never kept keys in the truck. The jury asked the question. And I thought that that was a great question from the jury.
It was a great question. Shows they're paying attention, they're listening to the testimony, and they're really trying to figure out whether or not the defendant's story added up. So he's made inconsistent statements after the accident, and then he made several inconsistent statements and failure to explain certain things on his cross-examination at trial. The jury obviously has been paying attention, and they wanted to determine whether or not they themselves could punch holes in his story, and that was a great question for them to ask. Prosecutor should ask that question, but the jury asked it, and I think that the witness was very strong, very positive, unimpeachable on that point and other points.
Yeah, it seems to me that at least somebody on this jury is really paying very close attention to the testimony, and that's the kind of juror that we want.
Exactly. There are jurors that tune out, but this is a murder case. It's an interesting case. It's an interesting fact pattern, and I think the jurors want to get it right. And probably more than just the one juror that asked the question. It might be collectively, or just because the jury doesn't ask a question in the courtroom doesn't mean they aren't paying attention. I think they're paying attention here. I think they have a lot to think about, but I think the thing they're really going to zero in on is the forensic evidence and the testimony of the defendant on the stand.
Yeah, exactly. So it goes back to the whole thing that, first of all, the case was partially sunk when he started babbling in the interrogation, and then going on the witness stand may have sunk him even more. But we're back in session in court, so let's listen into the judge.